today is the rule of law, which is one of the fundamental principles of democratic systems. In some ways, it even preceded democracies, as in Imperial Germany, which had a constitution and a fully functioning legal order that granted citizens a high degree of legal certainty and made the government conform to rules and laws. In the US, the rule of law has an even longer tradition that dates back to the times of independence and the history of the Constitution. Its shortest and most conclusive definition, I think, though, comes from an Englishman named A.V. Dicey, who lived in the 19th and early 20th century. As he saw it, the rule of law meant, first, that government must follow the law that it makes, and second, that no one is exempt from the operation of the law, and that it applies equally to all. Since Donald Trump began his second term as president of the United States, there has been a growing concern among legal scholars, legal practitioners, and citizens that the rule of law might be seriously threatened. Ruling by decree, as he has so often done, indeed raises doubts as to the first principle stated by Dicey, that government must follow the law that it makes, or rather that lawmakers have made. Historians might feel reminded of the later years of the Weimar Republic, when President Hindenburg basically ruled by so-called emergency decrees in order to bypass the parliament. So the rule of law and its meaning for democracy is our topic, and each speaker will address it from their own field of expertise. We will go by alphabetical order and start with Mohamed Camara, and I will shortly introduce you, Mohamed. You are a legal and political scholar at Columbia University who specializes in the intersection of law and social justice in African and diasporic contexts. Prior to Columbia, Mohamed studied politics and history at Sarah Lawrence College and worked in federal public defense, where he focused on policing and mass incarceration. Mohamed, the floor is yours.
Good morning, everyone, and thank you so much for that introduction. My name is Mohamed Camara. I'm a recent law school graduate, so you can imagine it is a pleasant break from the bar studies. It is an honor to be here with you all and to contribute to this important discussion, but also to get the chance to learn from you all. The question of rule of law is one that has, as just mentioned, long historical roots, and that, given the circumstances of our time, have important implications for us as well. In my 5 minutes, I don't have time to rehash the debates that have come about, but there are some certain points of convergence that we find, even between natural law theorists like Lawton Fuller or Joseph Raz from my alma mater here, Columbia. Those are that, among other things, that the law be general, prospective, equally applied, and also stable over time. And this definition of rule of law, sometimes called procedural rule of law, is not confined to a political philosophy or geographical location, but it helps to make real the idea that the law should be a guiding force in society, allowing us to sort of shape our lives in a way in which we can make sense of the state's corrosive power. What's happening now is that within the United States and abroad, there are breakdowns of these values that make law a functional one. And my understanding of this issue comes from my work with vulnerable communities. I've worked with, for example, Institute for Development and Human Rights Organizations in Africa that help with investigations, as well as helping victims of human rights bring their cases to African courts. But also, I work with marginalized individuals here. For example, recently, I Rise with Africans in the Harlem community who were trying to make sense of a really complicated immigration system. And prior to law school, I work with incarcerated individuals who are in state and federal correctional institutions. And I thought I should bring that perspective to this question because oftentimes when there are this breakdown in the rule of law, those individuals are often the ones who bear the brunt, at least initially, of these breakdowns. We are currently seeing the executive branch's stance on immigration, and the havoc that is causing members of our community is so undocumented. But it's also important that this breakdown goes beyond the executive branch. I think recently, actually, one of the biggest ironies that I'm seeing right now is that we are running to the Supreme Court for refuge in light of the executive branch's actions. But not long ago, and actually continuously, it's been very hard to find any discernible red guardrails against the court's power. It seems to be, it is overly political and in many ways antithetical to a lot of the value that we would traditionally attach to it. Abroad in Europe, I was recently in Hamburg, Germany, doing some comparative research between US and immigration policies and American immigration policies. And it seems like the Europeans are kind of pulling from a time from US policies. There is, for example, the new pact on immigration and asylum that's been considered, at least when I was there. And that is supposed to, among other things, make efficient the Dublin scheme, which has been in place for the last couple of decades. And what that essentially do is help allocate immigration responsibilities between different European countries. But human rights lawyers in Europe are kind of concerned about this new movement because they think that it will be a way to diminish migrants' right further instead of increasing them. And in Africa, where I was born, and my recent publication is on regarding its human rights court specifically, the similar trends are there. But more significantly for us, even though I'm approaching this question from that view of marginalized community, it is very clear that the breakdown of rule of law affects all of us. We are seeing now that universities, mine included, and Harvard's and others, are being pursued in ways that would have been unimaginable for many of us not long ago. Law firms, rich and powerful, and are exempt from this. So this is a problem that has wide-ranging effects and one that requires collective thinking and solutions around it. That leaves us to what to do. And I think context matter, and but having forums like this where we are diagnosing the problem is really important, even if it doesn't ultimately solve the problem. But to bring awareness of it is important. Actions that happen in legislative halls matter. Because in certain ways, for example, senators are in their position for at least 6 years. They are shielded from executive reproach in ways that other members may not be. And citizens on the streets and in voting booth matter, but those we can discuss later. Thank you again for having me.
Thank you, Mohamed, for also sticking to your time. That's a model, and I hope I will follow this model because I'm next. And I start with introducing myself, which I already partly did. I'm a modern historian who has worked on social, political, and gender history. And since I became director at the Max Planck Institute for Human Development in Berlin in 2008, after teaching at Yale for five years, I mainly focused on the history of emotions. My most recent book that has not yet been translated into English is on constitutional feelings in German history during the 19th and 20th century. And that's basically what I'm focusing on now. And I start with remembering an article in the New York Times that really pushed my buttons in October 2024. Then at that time, John Kelly met with a reporter from the Times and talked Tacheles. Kelly served as the White House chief of staff for Donald Trump between 2017 and 2019, before he fell out of favor and was discharged. 5 years later, he broke his silence about his former boss, whom he accused of not caring much about the Constitution or the rule of law. I quote from the New York Times, Mr. Kelly said that in the first few days of working for Mr. Trump, he had to explain to the president that top government officials like himself had taken an oath to the Constitution and would place that oath over personal loyalty. Mr. Kelly said Mr. Trump pressed him about that pledge and seemed to have no appreciation that top aides were supposed to put their pledge to the Constitution and by extension to the rule of law above all else. This, according to Kelly, was a new concept for Trump and, quote, I don't think it's one that he ever totally accepted. personal loyalty in contrast with virtually everything to him. I think this reflects a lot of what we've seen since January 2025. We've seen a president willing to go after anybody whose personal loyalty is under suspicion. We've also seen a president who has been governing by decree to an extent that seems designed to wear out his opponents. The sheer number of those decrees is exhaustive and exhausting. Challenging them as illegal and unconstitutional demands an effort that appears overwhelming. Still, a lot of them have been legally challenged, which puts the judiciary at the forefront of political action. The jury is still out. Will courts answer to what many see as an overstepping of presidential powers? Will they safeguard the Constitution against a president who does not seem to care for or about it? Will they defend civil liberties and constitutional rights against a president set on curtailing those rights and doing everything to install autocratic rule? Question mark. I'm not an expert on the American Constitution, but I do know about the reputation of the founding fathers who brought that Constitution into being. And I always wondered why the German founding fathers and mothers, who in 1948-49 worked on a constitution for West Germany, have never even come close to enjoying such a reputation. Researching those issues, I came across the work of a German Jewish legal scholar, Karl Löwenstein. He emigrated to the US in 1933 and taught constitutional law and political science at Yale and Amherst. In 1945, he became a legal consultant for the Allied military government in occupied Germany. As such, he was charged with investigating and arresting Carl Schmitt, whom he saw as a chief ideologist for totalitarian and fascist movements. Löwenstein also wrote widely about constitutional matters. For him, the US served as a paradigm of what he called constitutional feelings, Verfassungsgefühle. American citizens loved the Constitution and harbored intense feelings of attachment, commitment, and compliance towards it. In the US, he said, the Constitution still retained elements of the magic moment when it was drafted and proclaimed. Everybody believed in and cherished the Constitution as the foundational document of American democracy. It garnered pride and personal allegiance. At times, all this approached a kind of mythology that was a bit too much for the sober German-raised Löwenstein. Nevertheless, he stated and admired the profoundly integrative effect of those constitutional feelings, an effect that he saw missing in Germany, both in the Weimar Republic, where he had spent his formative years, and in the new Federal Republic that he came to know in the 1950s. Meanwhile, Germany's basic law has made advances on people's hearts. Since the 1970s, more and more citizens have put their trust in the Constitution, mostly in its civil rights section, which has been accepted as a general normative order. This is partly due to the fact that the Constitutional Court has been a major factor in expanding those rights. Furthermore, it has time and again held both Parliament and government to account in cases when they ruled against the Constitution. Although only 250,000 constitutional complaints have in fact reached the court since 1951, Germans share a feeling that Karlsruhe, the city where the court sits, is there for them and their concerns. But they have also learned to use the basic law as a political instrument and defend it against those who seek to destroy its normative order. Last year, after learning about a secret meeting among extreme right-wingers and their program of weakening the Constitutional Court and promoting remigration, 4 million people of different political leanings took to the streets over a stretch of several months and all over the country. Is there a lesson to be learned here? Defending the Constitution and the rule of law is first and foremost the task of the judicial system. But citizens are also well advised to practice their constitutional feelings and exercise them in open protest. These were my, hopefully, only 5 minutes. And now we turn to Deborah. Deborah Gonzalez is director of the Immigration Clinic and a professor at Roger Williams University School of Law, where she trains students to represent low-income immigrants in removal and immigration proceedings. She serves on several community and legal boards and is admitted to the Rhode Island and federal bars. Deborah, the floor is yours.
Good morning. Thank you for inviting me. I've been fascinated so far by the conversation. My task today was to discuss a reflection of the consequences of the Trump administration's policies and legal stands on issues of immigration for individuals, but also for American politics and the legal system and culture as a whole. I admit that in 5 minutes that's not possible to do. So I'm focusing my comments more in terms of how I have personally viewed this administration's use of the law and of the political system as a whole. As Ute just talked about, right, our Constitution has checks and balances. It was designed that way so that there wouldn't be an authoritarian sort of government. And this administration has certainly pulled away from that in various ways, in various ways. And I think one of the things, or there are several things that worry me about this administration, as we speak about the future of politics and culture and the legal system in the United States, is this idea and this notion that this administration makes decisions that are definitely and utterly not based on the rule of law and or makes interpretations of the law that are incredibly far-fetched and outside of the realities of what we see in the world or things that are happening inside of the United States. And one such thing that I wanted to talk to you about today is the interpretation of the Aliens Enemy Act. I'm going to call it the AEA, and how this administration has interpreted the AEA. So the AEA is a wartime law act, has been enacted probably over a century ago. I don't know the exact date. I apologize for that. That has been enacted only 3 times in the United States. In order for the Enemies Act to be in place, one of two things needs to happen. Either Congress needs to say, we are at war, and Congress needs to declare that because under our Constitution, only Congress can declare war, or the president can make a proclamation declaring that there has been an invasion of some sort. And so this act has been enacted 3 times in the United States during the War of 1812, World War I, and World War II. And it's really only been enacted as an invasion during World War II when Pearl Harbor was invaded by Japan after the bombing. I apologize for that. My computer is dinging. During the proclamation of the invasion, President Roosevelt, after the invasion of Japan on Pearl Harbor, issued a declaration that there had been an invasion. When we think of an invasion as the term invasion, right? Thinking about what does it mean to have been invaded. When you think about the invasion during World War II on Pearl Harbor, you're thinking about kamikazes coming into Pearl Harbor and dropping bombs on the people and therefore causing havoc, causing war. You can see that that definition means then really a true invasion. An invasion under Black law is defined as the encroachment upon the rights of another, the incursion of an army for conquest or plunder. So it's unclear that the term invasion, as it is listed in the AEA, would mean anything other than that. And yet this president, under his proclamation in March of 2025, declared that this gang, Tren de Aragua, from Venezuela, had invaded the United States. A couple of things are needed in order for an invasion to be considered an invasion. It also requires that the invasion be occurring under the authority of a foreign government. And here the Trump administration says, we have been invaded by this gang, Tren de Araguas, because President Nicolas Maduro, under the Cartel de los Soles, is ordering that this gang come to the United States and commit crimes and commit whatever it is that he alleges for them to have committed. And the proclamation then says, which the AEA requires, that anyone who is over the age of 14 from that nationality is to be apprehended or removed pursuant to other immigration laws in the United States. So I'm not sure if everyone on this call, considering this is an international call and is really exciting for me to be here, knows about what has occurred. But sometime in March, the president ordered the deportation of 137 Venezuelans to be deported to El Salvador, to a notorious prison in El Salvador, without any due process rights, meaning due process in the United States would require that the person be given notice and an opportunity to be heard in a legal court. None of these individuals were given that. They were apprehended on the basis of the federal government's belief, based on tattoos that these individuals had, that they were members of the Tren de Araguas gang. Now, when we think about this, right, we need to think about several things, not just the invasion. And I don't know if I'm going into my 5 minutes, but it seems far-fetched to me to say that these gang members have invaded the United States to the levels of which the invasion would be defined. So far, the government, the federal government, Trump's administration has only deported or detained 137 members of this presumed gang. It's even unclear whether or not they're gang members of TDA, as they've been formally named. I mean, I live in Rhode Island, we're the smallest state in the United States. I had never heard of this gang before, and I do an extensive amount of immigration work, working with immigrants from Venezuela. And I know of no true invasion as we should think of it in the United States. Certainly, Pearl Harbor would have been an invasion, and one could have seen that. But to say that these members of this gang have invaded the United States under some foreign government really is not clear. And in fact, when people have gone to the courts in Colorado, in New York, in Texas, all of the federal judges in those courts have said that the proclamation does not rise to a level of an invasion. Now, only recently, in May 15, 2025, did a federal judge from Pennsylvania, who was a Trump appointee, said that the administration properly used the AEA in as much as that she found that there was, in fact, an invasion of these gang members. It seems to me a couple of things. Well, so even if we think, for example, that there was in fact an invasion, so for the sake of this discussion, I'll agree that we had an invasion. The way in which these foreign nationals were deported from the United States is completely against our Constitution, in that, number one, they never had an opportunity to be notified that they were being deported because they were considered to be members of this gang. They were not giving an opportunity to be heard that they were not gang members. And more importantly, they were not giving an opportunity to be heard on whether or not they should be deported to a third country, which would require them an opportunity to argue that they would be maybe persecuted by gang members or the government in El Salvador. So it's pretty clear that this administration has taken this definition of this word invasion and came up with this super far-fetched idea of what an invasion would be in order to fit his idea of who should be deported from the United States, and then goes even further to not provide their constitutional rights of due process, of which any person, foreign national or not, who is within the borders of the United States is entitled under our 14th Amendment to due process rights of notice and an opportunity to be heard in any court. I think from my perspective too, in terms of what I am seeing on the grounds as it relates to our immigration system, it is very clear to me that this administration is looking to make America white again and trying to, and certainly doesn't understand that the United States is in fact a melting pot of cultures. And what he is looking to do is to bring us back to the Nazi government of the 1930s, where only whites are going to be allowed inside of the United States. I think I'm at my 5 minutes, and I'll be happy to answer any questions.
Thank you, Deborah. And that's a perfect transition to our next speaker, Benjamin Hett, who is a specialist on 20th century Germany and has written a widely acclaimed book on the death of democracy in Germany in 1933, around 1933. Benjamin is a professor of history at Hunter College and the CUNY Graduate Center. Benjamin, the floor is yours.
Well, thanks very much, Ute. I'm really happy and honored to be a part of this discussion. I see a lot of very distinguished friends and colleagues on the call. I'm going to, my remarks are going to be in a bit of a different direction. These are the remarks of someone who was trained as a Canadian lawyer many, many years ago and practiced law in Toronto for a little while, and then somehow became a historian of Germany. And I've ended up in my career writing a lot about German criminal law. So I'm going to say some things about the laws of criminal procedure. I'm going to talk a little bit about what that looks like in Germany. And then the point is going to be actually to illustrate a way in which there is an avenue through legal procedures to bring those constitutional feelings that Ute was talking about more forcefully to bear in our current legal predicament. So let me start. Back in the late 1980s, when I was a law student at the University of Toronto, I took a course called The Practice of Criminal Law from a gentleman named Edward Greenspan, who was, at that time, he's now died, he was one of Canada's leading criminal defense attorneys. And one of the things he said stayed with me, and that was, he would sort of growl this. He said, if you want to see democracy in action, forget elections, go sit for a day in the provincial court, watch ordinary mundane criminal trials and watch how hard it is for the state to put someone in jail. And that's where the rubber hits the road. Making it hard for the state to put someone in jail is kind of the essence of democracy. And I still feel that there's a lot of merit to that view. He also said that it is much harder.
You're frozen, at least on my screen.
Oh, okay. I'm hearing you.
No, it's fine on mine.
Okay.
I can see you.
I had a little trouble earlier.
I can't hear you. Can anybody else?
Yes, he's fine.
So what I want to say is the other point that Greenspan made is with reference to the two systems of procedural law that there are basically in the world. In the English-speaking world, there's what we call an adversarial system. On the continent of Europe and some other places, there is what is called an inquisitorial system, and they are profoundly different. They are more different than the substantive law is in either place. So let me talk a little bit about Germany. Germany's laws of criminal procedure date to 1877, and there are certain features of a German criminal trial that are interesting from a North American perspective. They don't have a party system, really. German trials are run by the judge. They're designed to be run by the judge. The prosecutor or the Staatsanwalt, there has been some debate in jurisprudence about whether the Staatsanwalt is a party, but the general consensus is that they are not. And if you look at a German courtroom, certainly older ones, you see this reinforced by the architecture. The Staatsanwalt, the prosecutor, who is another representative of the state, sits on a bench with the judge or judges. The defense attorney usually is positioned in a well below that bench. So even the architecture indicates a sort of subservient position for the criminal defense. And many aspects of the laws also sort of reinforce that. There are, for instance, basically no laws of evidence in Germany. There are no laws governing what can be put before a court and what can't, in comparison to the vast and complex laws of evidence in the English-speaking world. And this goes back to the point of a judge controlling what happens in a trial. The judges really have control in Germany. In the English-speaking world, it's the parties, and there are parties that run the trial. This was how it was in the 1870s. It tightened up considerably in the 1920s when Germany abolished the jury system for serious criminal trials. There were sort of Anglo-American style juries in Germany until 1924, when a law called the Lex Eminger abolished them. The real reason here was that juries were likely to acquit in many instances, for instance, cases of perjury. And predictably, when the jury was abolished, convictions for perjury shot right up. It was much easier to get them from a judge. So again, sort of reinforcing judicial, which could very easily be state control of what was happening, and making it harder for other views to be manifested in the courtroom. Not surprisingly, this got worse under the Nazis. Among other things, the Nazis introduced what were called special courts, or Sondergerichte, which went even farther to eliminating other ways to bring arguments or evidence into the courtroom. It wasn't required to have a defense attorney in a special court. Trials were meant to be speedy. There was no right of appeal. Often executions followed immediately after the conclusion of the trial. Then I want to mention a matter of what I would call culture. This again gets a little bit close to what Ute was talking about, constitutional feelings. There are cultures around how trials are conducted. Cultures basically involve norms of what's going to happen and not happen. And sometimes the culture can augment or undo rights that are given in kind of black letter law. One of my favorite examples, drawing from some research I did a long time ago, in the 1877 Code of German Criminal Procedure, it was very clearly stated that the accused person had the right to remain silent, both in the investigation and at trial. But in 1892, 2 lawyers were dragged before their professional discipline tribunal because they had told their clients that. And the attitude of the bar and of the judiciary was, sure, a criminal defendant has the right to remain silent, but you can't tell them that because they're criminals. And then if you tell them that, they won't testify and we won't convict them, even though that right was clearly there in the law. So that's a matter of culture. That's a matter of culture around these laws, which has an impact on how the laws are actually carried out. Now, what does this have to do with where we are right now? So the United States, like all English-speaking countries, has an adversarial criminal justice system where the judges or the jury, as the case may be, as triers of fact, are supposed to be passive, and evidence and argument is presented by 2 distinct parties, prosecution and defense. What this means is there is a much more concrete way of introducing evidence and argument into the proceedings, and it's harder for the state to control what happens. And particularly, it's harder for a state that wants to be authoritarian to control what happens in a courtroom, because there are different power centers in an Anglo-American court. And one thing I think we are in the process of learning in the United States, and we will learn plenty more over the next 3.5 years or so, is how much it matters when there are different power centers, and how much it matters when there are power centers that the state cannot get a hold of. And it's much harder for the state to get fully hold of a criminal proceeding in the United States than in an inquisitorial system, which is, just to conclude on this note, which is something that Eddie Greenspan also said in that classroom at the University of Toronto many years ago. He said, there has never been a dictatorship that had an adversarial system of justice. There have been plenty of dictatorships that had inquisitorial systems of justice. I think empirically that's probably still true. In the United States in the 2020s, we're putting it to the test. We'll see where we are in 3.5 years, whether we have a dictatorship with an adversarial system of justice. I actually remain somewhat optimistic that our culture of the rule of law, our constitutional feelings, if you will get us through this moment, maybe by the skin of our teeth, but we will see. So I will leave it there. And of course, I'm happy to come back to any of this in the questions.
I think you're muted, Ute.
Yes, I was muted. Thank you, Benjamin. And our last speaker is Samuel. Samuel Miner. He joins us from Munich, I think, from the Institut für Zeitgeschichte for Institute for Contemporary History in Munich. Sam is a political historian and commentator who focuses on democratic development, constitutional crises, and the historical foundations of the rule of law. So please proceed.
Yeah, so thank you, Ute, for those words, and to Christina, and also to Colin, Theo, and Moritz for organizing these events, which I've enjoyed listening to all of them, and also to the panelists for their thought-provoking statements. I'll keep this short by reading my comments. As this is a gathering of historians, I'd like to start with a plea. Courts are an essential part of the current struggle over the meaning of democracy, and as such, it is a central task of contemporary history to research the history and role of courts in democracies. In the United States, Poland, Hungary, Israel, and across the world, courts have become the first battleground between populist authoritarian governments and the established traditions of constitutional democracies. Since World War II, there has been a proliferation of Supreme Courts, and along with it, an increased judicialization of politics, which has received attention from political scientists and jurists, but is only belatedly being the subject of historical analysis on a global scale. In Germany, the recent electoral success of Alternatives for Germany, or AfD, and the conclusions of the Office for the Protection of the Constitution in a report that the AfD has, quote, confirmed right-wing extremist tendencies, is just the latest in a long and growing transatlantic dialogue about the need for courts to fight the emboldened far right. Germany provides a powerful model for opponents of the Trump administration who want to see him face legal consequences for his unconstitutional acts. Historically, this model came from two of the major novelties of the 1949 post-war West German Constitution. These were to create a federal constitutional court empowered with broad powers of judicial review and a web of legal institutions designed to combat constitutional enemies, as the term goes, of the free democratic basic order. Those are pillars of Germany's militant democracy. The Constitutional Court should decide in the end if parties are incompatible with the Constitution and is therefore considered to be a guardian of the Constitution. It banned two parties in the 1950s, the Communist Party of Germany and the so-called Socialist Reich Party, which was a clearly successor party, the National Socialists. Experience suggests that the court sets a very high bar for party banning cases. What is unique, as opposed to earlier Cold War discussions, is that in the United States and in Germany, it is largely the political center-left that are most in favor of empowering the courts to ban parties, whereas it had largely been a matter for Cold War liberals and conservatives in the 50s, 60s, and 70s. The major point of my own research into the origins of the German Federal Constitutional Court and militant democracy was that these are legal constitutional developments deeply entrenched in German national history, not a copy of American constitutionalism or an export to Germany through Allied occupation. They were also not just the response of a country which had once tried democracy in Weimar but collapsed in dictatorship after the electoral rise of the National Socialists. Rather, they were also the result of 12 years of a dictatorship by popular consent, in which large portions of the society supported or turned a blind eye to the persecution and genocide of European Jewry and fought to the bitter end to defend that regime without a major resistance movement. In the Jewish emigre jurist Ernst Frankel's still essential analysis of Nazi Germany, the Nazi regime was a dual state in which pseudo-legality existed alongside the extra-legal measures of which we are also well aware. Judicial review by a Supreme Court was a way to comb through Nazi legislation still used in the post-war to defend war criminals, and in the post-war militant democracy before it became clouded by the Cold War logic of the 1950s, was the innovation of anti-fascists who wanted to extend denazification after it fell apart during the Allied occupation. In one important sense, I think the crisis of American democracy does reflect that post-war change in West Germany and maybe a change in constitutional feeling. Twice the American electorate has voted for Donald Trump, and at least in the second election, he won the popular vote with 77 million voters. He has a slim majority in both houses of Congress. The hope that the judiciary might ward off some of Donald Trump's most authoritarian measures is of course grounded in the belief that the rule of law means courts defend against violations of statutes and the Constitution. It is also, however, the reflection of a profound fear that a growing number of Americans are lost to democracy, and therefore non-representative institutions such as courts will save us from the electorate and in the end save us from ourselves. Frank Bies called the history of the Federal Republic a history of angst. For very understandable reasons, liberals in the United States view their fellow citizens with a great deal of angst too. Just as militant democracy was a solution to a problem of German history deeply rooted in German problems, so too, I hope that American liberals can find a solution to the very American problems of Donald Trump and imperial presidency with the electoral victories and congressional self-assertion. Thank you.
Well, thank you very much, Sam. Thank you to all of our speakers. We have not 30 minutes as planned, but 20 minutes left for a general discussion that can also kind of be led between the five speakers. But as we have spoken quite a lot now, I would rather turn to our audience and ask them to come in with questions or comments. Please do raise your virtual hand, and please don't send me messages in the chat. That's too complex. I can't do both. I just look out for virtual hands. I don't see any at this point in time. So maybe I can kind of come back to Benjamin's intervention and ask you, Ben, do you actually, I mean, I love your optimism about the judicial system in the US to withstand and not turn into this, it was kind of a new concept for me, the inquisitorial system, but stick to the adversarial system. Do you see any signs that this might change, that, you know, we are kind of surprised to hear from this administration every day, new things, surprising things? Do you see signs that this is already in the making, that people are actually trying to shift certain powers within the court?
Well, I think probably the clearest is the way Trump has gone after law firms with executive orders, trying to shut down law firms, basically taking cases against him. And some have caved and some have not. And I think the firms that have not caved are doing what I would hope they would do, and in a sense, playing their role in the adversarial justice system. I read an interesting story the other day, I think Friday maybe, in the Wall Street Journal. There was a story about how with some of the firms, most famously the great litigation firm Paul Weiss, that caved into Trump's executive orders, Paul Weiss and other firms are actually getting hurt now by their clients leaving them, because clients, even like big corporate clients, are saying, I want a lawyer who will fight, not a lawyer who will cave. And I think God bless them. I must say it fills me with schadenfreude, to use a nice German word, to think of these firms who knuckled under to Trump now paying the price exactly where they don't want to pay it in terms of business. So I think that's an example of what the administration is trying to do to the justice system and how it can be fought. I mean, it's a big complex story, and there are others, but I think that serves to kind of illustrate the point.
Thank you, Ben. So I see Kenneth, and I know that you have been a lawyer, just like Benjamin, before then turning historian. So Kenneth, the floor is yours.
Yeah, I would like to pose the question to all the panelists about, we've dealt primarily with criminal law aspects, or certainly Benjamin has. The challenges in the Anglo-American system that we're grappling with now tend to appear more on the civil side, but that's because of the Anglo-American neglect of administrative law. And I spoke about this a couple of sessions ago. The tradition, both in Britain and British-influenced countries, seriously British-influenced countries like Canada and the United States, has been for greater protection of criminal defendants because of the immense power of the state to destroy the life of a criminal person, of a criminal defendant. But the way things are having to be pleaded now is on the civil side of courts, which is where the administrative jurisdiction, the public law jurisdiction in the Anglo-American system falls. I think of Deborah's clients dealing with immigration kinds of issues. That's an administrative law issue, but that appears in American courts as administrative law. Could you, obviously the distinctions are really different. We're seeing conscious pushback against the administrative law tradition in Germany. J.D. Vance and Marco Rubio and their denunciation of the Verfassungsschutz decision and that whole process shows an incomprehension or opposition to that. So I'm actually more comfortable that the Germans, with their militant democracy, and I really like the invocation of Karl Löwenstein, who is the originator of that. But could you speak to this civil and criminal division, please?
I think this question goes mostly to Mohamed and to Deborah.
Yeah, I think I can take a crack at it. I think at least in the immigration space, and even as a paralegal, you would have clients come in sometimes, and we are dealing with. I was a federal defenders here, so like all of our clients were dealing with federal crimes, and a lot of the time, what you find is like that sort of bifurcation of it, criminal and civil, was not really there, because if you, for example, re-enter the country once you've been deported, that is a federal crime. So in that sense, the divide can be very murky, and I think, and because immigration generally tends to fall under the powers of the executive branch, they can have a really almost near control over what that process looks like, because the executive tend to have sort of a plenary power over immigration matters as it has to do with international relations. So in that sense, yes, the divide exists theoretically, but I think depending on the stance of the executive branch, it can be really murky, and the consequences can be that much greater, because there's little check on the from the other branches on that power of the executive.
Deborah, would you like to add?
Yeah,
something?
I'll add to that in as much as what we're seeing today on the ground, and I practice daily in the immigration court, is we're seeing judges, because administrative law judges are appointed, they apply for a job and they get the job, right? It's not like an Article 3 judge that has to go through sort of through an appointment issue by a president, or if it's a state one, by the governor, or some sort of judicial nominating committee or something along those lines. An ALJ is not that. An ALJ is someone who may have worked for the government, or it could be a private person who sees a job posted, applies for the job, and gets the job. The ALJs in immigration court are incredibly controlled by the Attorney General, who is a Trump appointee. And so you're not seeing ALJs being objective in their decision. There is no objective party as it relates to ALJs in immigration court. And in fact, the American Immigration Lawyers Association, AILA, of which I'm a member, has been fighting with Congress to make immigration judges Article 3 judges and not ALJs, because there is no independence. If I just recently, I heard from a colleague, a judge made a ruling on a bond case in Boston. The client was being held in New Hampshire. The court said, I don't have a motion to change venue, meaning that they would change the case to New Hampshire. None was pending before the court. She issued an order on the bond and then received a phone call from her higher up saying she had to reverse the order. Right? No appeal. Where's the due process in that? There is none. And so the immigration court today is definitely being ruled by the administration themselves, and ALJs in immigration court have zero independence to make any decision whatsoever, which I think makes then the court itself really just a puppet of the administration.
That doesn't sound good. Next
Sorry,
question.
can I say something really fast? Ken, I would say wait. With these arrests of judges and with Trump's desire to prosecute his enemies, we'll get to the criminal stuff, I'm pretty sure.
Doesn't sound too optimistic now. So next speaker, commentator is David Abraham.
Yes, as long as we're continuing on this optimistic vein, let me raise the issue of obedience to the law by those who are in power. So it's one thing to take the immigration example for Trump to pronounce that the country has been invaded by gangs that are in some way an arm of a very unpopular Venezuelan regime. But he has lost that case in court after court and lost other cases in court after court, with so far only minimal obedience by the executive branch to those decisions. And the fact is that there is almost no mechanism in this constitution of ours, and I'd be curious about the German comparison. There's almost no mechanism that can compel the executive to carry out a court's order. It depends on the willingness of the executive to do so. And there are two primarily options that a court has. One is to levy fines against a recalcitrant executive, and the other is to order the arrest of officials who should be but are not carrying out those orders. Current legislation before the Congress, which the Republicans may well succeed in passing, would take away from courts the ability to monetarily fine recalcitrant members of the executive who do not carry out judicial orders. So I guess it's a twofold question. One is, how does that work? How would that work, or does that work in Germany? And what does that say about ultimately the consensus or legal consciousness that is necessary for a legal regime to work? We have not had this kind of challenge in the United States since the Southern governors refused directives to integrate their universities more than half a century ago. So the question of what are the mechanisms of consciousness and institutional responsibility that lead the law to mean something after it comes through the courts in general, and how that would look in Germany.
This reminds me, David, of what Marian Kaplan said in one of our conversations when we addressed the very same question. What happens when the administration just doesn't obey the courts and just and nobody could answer it, and nobody can answer it in Germany? I think there is one answer which is not in the books, that people have to go out on the street and really protest. Otherwise, I mean, the courts themselves are probably not in a position to enforce policies. The enforcing side is always the executive and not the the judiciary. And when the executive just doesn't care, it's up to us, it's up to the people to, as the Constitution says, to defend the Constitution. But I don't know, Sam, if you would like to, or Benjamin, to say something about German provisions in this case.
Not my wheelhouse there, I think. Sorry.
Sam?
I am trying to think. During the 1950s, the Federal Constitutional Court did get into a number of pretty severe conflicts with Konrad Adenauer, where the Adenauer government in several instances said it was unwilling to carry through on the letter of everything that the Constitutional Court said. But by and large, it was solved by internal mechanisms of the kind of ministerial bureaucracy intervening between the Federal Ministry of Justice, saying, you know, we're going to put our hands on the scale this way. And frankly, the Federal Constitutional Court willing to be remarkably ready to compromise when it came to some of its decisions in a way that integrated it into the political system at a time when it was most delicate. I don't know past the 1950s if that's been the case.
Well, there have been cases even later when the government didn't really like what the Constitutional Court has said, had ruled. but it's still, and that's part of the self-definition and self-understanding of a democracy, that there is a division of powers, and that they have to abide, and when they don't, we have a problem. So Hartmut Kelbler, is that you?
Yes, I'm here, yes.
Great.
I found these 5 interventions very good, excellent for this discussion on the rule of the law. And I think there were good reasons that there were 2 points which were mainly accentuated in these 5 interventions. This was first the sentiment, the trust of citizens into the rule of law and the Constitution, and secondly, the resilience of the judiciary system. Now, my question is, I have 2 questions. One question is, what would be the role of a good or bad constitution for the rule of law? Do you think that the German constitution in the Weimar Republic was less ready for a good rule of law than the American Constitution? Is this an important factor, the Constitution as such? And secondly, do you think there are important differences in the value system of the political elites? Do we have some political elites which are more inclined to support the rule of law, the rule of constitution, which we really talk about? And are there other elites which would not be ready to the same degree?
Thank you for these questions. Hartmut, who wants to answer? Nobody?
Well,
Next
maybe
one.
I'll just say very quickly, I think that's a great question. Here's my kind of maybe surprising to some people, ex-lawyers answer. The written law doesn't matter very much, actually. The Weimar Constitution was perfectly fine. The American Constitution as written is perfectly fine. You mentioned values of the elites. I would say that's much more important, actually, in terms of how the Constitution is going to be lived. And this is always the case. I mean, in law school, one thing I learned is the Canadian Constitution basically creates a dictatorship, just on the black letter of the law. And there's, for 100-odd years, there were no individual liberties in the Constitution, but Canada did more or less okay as a democracy. Point being, the culture matters, not the actual legal text.
I would absolutely agree with Ben about that. I think one of the criticisms of Weimar was that it wasn't militant enough, and I don't think that's actually correct. If you look at things like the Republikschutzgesetz that was passed, there were actually attempts to ban radical political actors. The problem was elites. The problem was overwhelmingly that the judiciary itself didn't want to carry through on the letter of the law, and in any number of important situations, they in fact betrayed the Constitution and betrayed the laws that they were decided to uphold. So I would agree maybe with it. I think Ken Ledford said this in a previous episode. Part of the problem is the structure of the judiciary and the way the judiciary was trained in the Weimar Republic, and then even some of the ways that the judiciary is still trained leads to a kind of structural conservatism, which can be very harmful when you have the wrong people in power.
Thank you. I have one last speaker, Ralph Fortunato, very, very shortly because we're running out of time.
Yes, I'll make this short. Just a quick comment that I'm glad you guys are more optimistic than I am, but I'm pessimistic when I look at the administration saying if we don't like a court ruling, we're not going to abide by it. I'm looking at what happened in Poland this past week. I'm looking at the government in Denmark collapsing today, the rise of authoritarianism. And I remember that people who study Germany probably answer this better than I can, but I read it somewhere that in the 1930s in Germany, the pessimists left and the optimists went to the concentration camps. So I think we need to get rid of our rose-colored glasses and be a little more critical on this. Thank you.
Thank you, Ralph. I think we are critical, but we should not be pessimistic, because pessimism, otherwise different from the quote that you just gave us, is probably not a good advisor in this situation. So I have to close this session. Thank all of our speakers. Thank most of all also to the staff that made this possible in Bielefeld and in Bonn and in New York, of course. And most of all, I thank our wonderful Christina Morina, who has brought these transatlantic conversations into being and who will chair the next and final one, possibly last conversation that will take place on June 17 on liberal democracy and capitalism. I hope to see you all on June 17, same time during the day. Thanks a lot and bye-bye.
Bye-bye.